be on video. So, which case would you like to take first, Mr.?
We have Mr. Duvall here.
Okay. Come forward, please. Court of Call People versus Larry Duvall, file number 25504-5409. The record should reflect Mr. Duvall is present here in the courtroom today.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Duvall.
The sentencing on a delay of sentence.
He was successful in his probation, I think is what we're here for. He's going to withdraw his plea, and it's going to be reduced to lewd and lascivious behavior.
That is correct.
Okay. Can't find it, but I do recall reading the.
Does the court, I have a copy of it.
No, that's fine. I recall reading it and that Mr. Duvall had complied with all the conditions of the delay. Ms. Cook, is there anything you wanted to state?
The lewd and lascivious conduct, which we don't do very often, is PAT code 750.335. It's a 1 year and or $1,000 misdemeanor. I don't have anything to add. I hope that Mr. Duvall learned his lesson and we don't see him here again. 57 years old. He's had very limited criminal history. It's been many years, and I'm hopeful that we don't see him here. Thank you.
Thank you, Mr. Church.
I would echo the same sentiment, Your Honor, that, we don't get to do a lot of these hearings that are just generally positive hearings. But, when I first met with Mr. Duvall, he told me this is not who I am. Fortunately, we were able to get an offer from the prosecutor's office that gave him an opportunity to show the court that. And I think he's taken full advantage of that and done exactly what he said he was going to do. As the prosecutor myself, and Your Honor, I'm sure are well aware, not everybody who gets that opportunity takes advantage of it. So always a good thing when we see someone who does.
Thank you, Mr. Duvall. Is there anything you wanted to say?
No, sir. I just followed everything that they asked me to do, and I'm, like I said, it's not who I was, and I'm not who I am, and you won't have any issues. I'm moving forward.
So I did read through the original PSI just to familiarize myself with the case and the actual background of that prior to the hearing today. I did review the report that indicated that you did fully comply with all the terms of the delay. I think given the underlying circumstances, which were not good, certainly, and the actions that you undertook at that time, not something that I hope you will be. But I also think looking at your past history and those circumstances that this is a reasonable outcome. And I think that could be fully complied with everything that you were required to do during the term of the delay shows that you have committed to not repeating this type of conduct again, and committed to following all the conditions that you were required to follow over the period of the year. So for all those reasons, I agree with counsel that you should get the benefit of the delay. The court will order that the conviction for the lesser charge be entered and the conviction vacated. And is there anything else that Mr. Duvall needs to do in terms of his delay?
No, not on my end, Judge.
All right. Did you have any questions at all?
No, sir.
Okay. Thank you. That's all.
Your Honor, I think since this is a sentencing on the delay, it's a misdemeanor, so I think he has oral advice of rights, but I think he needs appellate rights.
Okay, that is correct. So, Mr. Duvall, I don't think we gave you any kind of advice with regard to your rights to an appeal at the previous hearing because it was a delay. Since you are now going to be, there will be a conviction as to a misdemeanor entered against you. You still have the ability to seek an appeal of the sentence in this case. If you wanted to do that, then you would need to file for that appeal within the next 21 days. If you have additional questions about how to do that, Mr. Church will be able to answer those questions for you. Other than that, that's all for today. And thank you.
Thank you.
So.
Mr. Van Sickle.
Court calls People versus Kyle Van Sickle, file number 265530. The record should reflect that Mr. Van Sickle is present here in the courtroom today. If I could have counsel put your appearance.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Van Sickle.
All right, we're currently set for trial to begin in this case. This is the final status conference of plea cutoff. Mr. Trush, have you been able to go through any or the plea offers with Mr. Van Sickle?
We have.
Okay, how does Mr. Van Sickle want to?
Well, we would be intending to proceed to the scheduled trial.
Okay. Ms. Koch, are the people ready to go forward as scheduled?
We are.
Mr. Trush, are you?
We are.
Ms. Koch, are there any matters relating to the trial that we need to address here on the record today prior to the morning?
No, we have everybody served and we don't have any witness issues or any other issues. I suspect it'll be a difficult case to pick a jury from just because of the type of case it is, but we're prepared.
Do you still anticipate the trial taking 2 days?
I think it'll be done in one day, but I always think that. So it depends on how many witnesses the defense calls.
I think 2 days is probably the appropriate amount of time, just because I share the prosecutor's concerns that it's going to take a little longer than usual to pick a jury. And while I can't be certain of how many witnesses we're going to call, because it's flexible, obviously, with the trial, I do anticipate at least 2 to 3 defense witnesses, possibly as many as 5 or 6.
Okay.
I am prepared, though, to address jury instructions with the court. The court were inclined to do that today.
I haven't had a chance to look at what the parties have submitted. Do we have any issues with the preliminary instructions at all? Or are the issues confined to final instructions?
I think most of them are confined to final instructions. From my perspective, there aren't really any issues. The prosecutor requested one that I didn't request, which I think she's entitled to. Likewise, I requested one that she didn't, which I think is also appropriate. And then we both made a mistake on the final elements. I think the prosecutor cited CSC 4th the proper way. I gave the wrong instruction for that. And she gave the wrong instruction for the, I think, incest portion of it, but I had the right one there. So we might need, it's just the numbering that's wrong. I mean, the actual instructions are the same.
Okay. All right. So I think we can, we can deal with the final instructions once the proofs are closed. So as long as there aren't any issues with the instruction.
The only potential issue that I saw there, and again, I don't remember exactly what instruction it was on, but one of the prosecutors, I think, referenced a different defendant. And again, I'm sure that she puts them together from existing instructions, same way I do.
And I'll go over all of them with Mr. Trush and see if we can't fix the ones that, that he's discussing that he had wrong and we had wrong. Usually we're able to resolve all of them.
Are there defendant jury instructions in the file? I show prosecutors only. Maybe paper is clipped to the back of the file.
Yeah, no, we just have equals.
I apologize, Your Honor. We did them weeks ago, but must not have sent them out.
Well, I think they may not be in the file, but I did see an email, so I think they may have sent them electronically to Jennifer, but just not filed a copy.
And I got them on 7/16 from defense.
I was
So
gonna say, I thought I saw them from
Well, it makes you feel a little better.
you. All right. Okay, so then we'll proceed as scheduled. Mr. Van Sickle, it's just important that you stay in touch with Mr. Trush, and we'll need you to be here and ready to go by 8:30 on the morning trial. Trush, anything further today?
No, Your Honor.
Ms. Koch?
no,
All right, thank you. That's all. Mr. Fletcher's, give Mr. Fletcher's case.
I don't see Mr. Fletcher here yet, and I did ask my office to reach out to him.
About Mr. Bramer.
We do have Mr. Bremer, but we are a little early on that, and that is a victim case. Mr. Saylor and Mr. Barr are both here.
Court calls People versus Michael Saylor, file number 245346.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trish on behalf of Mr. Saylor.
Actually, two files, also 265579, the record should reflect Mr. Saylor present here in the courtroom today. Mr. Truce, how did we want to proceed on these matters?
Thank you, Your Honor. When we were last here, we asked the court to adjourn this so that we could get these two files sort of linked up together. We have an offer from the prosecutor that contemplates an admission to the OWI third offense with the enhancements, the habitual enhancements being dismissed. I think we're ultimately going to take advantage of that and ultimately admit the probation violation as well. From talking to Mr. Saylor, though, he's indicated to me that his family owns some property in Otsego County. After discussing the different permeations of what could happen at a sentencing, he's asked if we can have him screened for the Otsego County Sobriety Court. So I've put all that information together and that application has gone out. So I'd ask the court to consider giving us maybe another 30 days or so to explore that. I think in 30 days, we'll probably have at least a good idea of if he's going to be a good candidate for it or not. From talking to the prosecutor, again, as we kind of see it, the likely outcomes there are a potential MDOC sanction where he's eligible for boot camp. I think we both agree that he would be better served with the sobriety court if that is an available option for him.
This vote be an objection.
I don't have any objection. I did sign a agreement to be screened for sobriety court with the caveat that I think that if I would agree to it if the court were to give him at least 6 months in jail. I think this is his 6th OWI, which is why the MDOC sanction is basically the only thing up. And I don't think it's appropriate for someone to get no jail on an OWI 6th. So we put that caveat together and sent it off to sobriety court earlier this week.
All right, Mr. Saylor, have you talked to Mr. Truce about this? Yes, sir. Do you agree with that? Yes, sir. Okay. All right, so we'll set this for status conference plea hearing in September. Do you think we'll have an answer by that time?
I think even if we don't have everything completed, I think we'll know if he's going to be accepted or not.
Thank you. Mr. Saylor, do you have any questions? Oh, thank you. That's all. Thank you. People versus Bob, file number 265544.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trish appearing on behalf of Mr. Bond.
This is the date and time set for sentencing in this matter. Mr. Bob, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Truce about that? Yes. Are there any additions, deletions, or corrections?
No, Your Honor.
Scoring of the guidelines.
No, Your Honor.
Scope for the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
When I read this, I actually went back and read it twice. We don't see meth in the form of pills very often. I think that's a dangerous situation. I know the recommendation here is 7411. I hope that he takes it seriously. I understand he has 2 prior felonies, but they're really old. My biggest concern is that he doesn't think he has any substance abuse issues. There's people who possess substances either have a substance abuse issue or are selling the substances. There's no other reasons to have them. So I hope that he takes it seriously. At 36, he's kind of in a crossroad. He can either start making good life choices or keep going down this path. So hopefully we don't see him again. Thank you.
Thank you, Mr. Truce.
Thank you, Your Honor. I would echo some of the same sentiments as the prosecutor in regards to this. Mr. Baugh presents to the court in a somewhat unique circumstance, but frankly, the point of this is his prior record variables score out a little bit high because of some, again, admittedly older, but prior felonies he has on his record. And frankly, with the opportunity here to keep this off his record, he's not going to have a lot more of these opportunities out there. I see he had a HIDA in his past. He's now able to take advantage of 7411. again, it's well put by the prosecutor. If he continues the pattern of behavior, the penalties are going to go up, and he's going to find himself in jail or an MDOC. From talking to him, he has a plan to get his life on the right track and take care of some of these issues that are dogging him. And I hope he does take advantage of that.
Thank you. Mr. Bob, was there anything that you wanted to say today?
Yes, first and foremost, I want to set responsibility and accountability for my actions. The decision that I made, because that's the thing that I was charged with. I mean, I understand the seriousness of the charge. I understand it. I mean, substance abuse treatment will be good for me, but I see that I need more mental health and substance abuse. The mental health issues made me make the bad decisions, wrong decisions that I made. Was more of substance because I control myself, just more of the mental aspect. So I'm gonna be a better man. I just had a baby like 3 weeks ago. I got one son, so I have things that keep me sane and focused and help me be like strong and be supportive, to be like better to change. I understand. I appreciate the prosecutor speaking from what she said. It's like an eye opener. Some things I gotta hear from other people to get a better understanding of what it is I need to do to be a better man. So that's pretty much it.
Well, Mr. Ball, I did read through the pre-sentence report, so I'm familiar with the incident that brings you before the court here today. There's also a lot of information in that report about you and your background and circumstances. I take all of that information into consideration along with what the lawyers had to say and of course what you had to say here today. I think looking at the underlying circumstances that this is an appropriate resolution of this matter. You don't have any prior drug offenses, so you do qualify for probation under 7411. And I think given the nature of the underlying offense, it's appropriate to give you that opportunity. And so the court, that recommendation, the court is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions in the report. And that includes that you comply with any drug testing that you're directed to do by your probation agent, that you not use or possess any controlled substances or drug paraphernalia unless it's prescribed to you, as well as all the other conditions. The court is going to order some jail time, but I'm going to hold that in abeyance. And so if you successfully complete your probation, you would not have to serve that jail time. However, if you violate your probation, then the court can order any or all of that jail time immediately. So I hope that that will provide an added motivation to you. The court is going to order 6 months in the Crawford County Jail with credit for 2 days served. Again, that time can be held in abeyance to be served at the discretion of the court. Court will order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, $68 state costs, supervision fee while you're on probation, $30 per month. Because this sentence is pursuant to 7411, there are no appellate rights at this time.
Yes,
Mr.
I'm going to speak with him right now, Judge.
Mr. Bob, make sure that you touch base with Mr. Falda before you report today. And good luck going forward. Thank you, I appreciate it. People versus Michael Marvin, file number 245339.
Sierra Coke on behalf of the people.
Reflect Mr. Marvin's present here in the courtroom today. Marvin, you're here before the court today for this is a probation violation?
Yes, Judge.
Correct. What's that?
Need a copy?
If you have one, it might be quicker. Mr. Marvin, have you been provided with notice of what the alleged violations are?
Yes, sir.
Okay. I need to go through a few things with you with regard to your rights. You do have the right to have a hearing as to whether or not you did violate the probation. You also have the right to have an attorney present in any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Trush is one of our appointed attorneys. He's here present today. If you wanted to consult with him here today, I would give you the opportunity to do that as well. If you are found guilty of the probation violation, it could subject you to the maximum possible penalty on your underlying charge, which is up to 5 years. Do you understand all those things that I've stated?
Yes, sir.
Did you want to have an opportunity to speak with an attorney before you?
No, sir.
Did you wish to request a court appointment?
No, sir.
Are you going to hire your own attorney?
No.
Okay, so you're going to represent yourself on this violation?
Yes, sir.
So I need to go through a few things with you with regard to that. Have you ever represented yourself in court before?
No, Your Honor.
Do you have any legal training, education, or experience?
No, Your Honor. I do just plan on pleading guilty to it though, so that's why. But I don't really need an attorney, I believe, to do that.
Okay, and that's fine, but I still want to go through some of these
Yes, sir.
things with you.
Apologies.
Because it's almost always unwise to represent yourself. It's kind of like, you know, if you had appendicitis and you needed your appendix taken out. That's not something you would want to do on your own. The legal world is very similar to that. And even though you're indicating that you want to plead guilty, there could be other options that you might have that an attorney could advise you of. There also may be consequences by pleading guilty that an attorney could advise you about, make you fully aware of. And without that kind of advice, and without any legal training or experience or education on your own, you're not going to know about those things. It could result in a worse outcome for you. It may not. But do you understand those risks?
Yes, sir.
Okay. And in light of those risks, you're still willing to go forward without the advice of counsel?
I would talk to counsel, sir.
Okay, so Mr. Trush, do you have 1 minute to talk to Mr. Marvin?
I do. Can I have a copy of the violation to?
Yes. And we'll pass that matter for a few moments here. And actually, we're ahead of schedule. So let's just take a short recess, give Mr. Marvin an opportunity to speak with counsel, and we'll come back on the record in about 5 or 10 minutes.
Thank you.
We're back on the record in Mr. Marvin's case. Mr. Marvin, did you have a chance to talk to Mr. Trush?
Yes, Your Honor, thank you.
How did we want to proceed?
Thank you, Your Honor. I had an opportunity to talk to him as well as Mr. McFalda. At this time, he's not going to be requesting the appointment of counsel. From talking to Mr. McFalda, the request is going to be to adjourn it down the road and monitor it. If he continues with the treatment regimen that he's on, I think the idea is to dismiss it ultimately. I also went over with him just to make sure he understood the difference between technical and non-technical as maximum penalties, all of that. But it makes sense to me. I think it's reasonable for him to continue without an attorney at this point, with the understanding that if any point in the future, that's not what materializes, he always has the ability to ask for an attorney. And I also gave him our office's contact information.
Okay, Mr. McDowell, anything you wanted to add to that?
No, that's true, Judge. Mr. Marvin is engaged with VA services. I'm gonna monitor that. I just asked this be set out 90 days. And if all goes well, there's a good chance I'll dismiss this at the end.
Okay, so Mr. Marvin, for purposes of today's hearing, I'm going to enter a not guilty plea on your behalf with regard to the charge. And then we'll set it for a hearing in 90 days, and then just make sure that you stay in touch with Mr. McFalda. Did you have any questions at all?
No, Your Honor, thank you.
Thank you. That's all.
Thank you, sir.
We have Mr. Bremer.
Mr. Bremer is here.
Okay, Mr. Bremer, if you come forward, please. People versus John Bremer. This is file number 265572. The record should reflect Mr. Bremer's present in the court today. Come in status.
Thank you, Your Honor. This is our first hearing up here in circuit court on this matter. A lot of information has changed hands, so to speak, in the last probably 10 days. I had a very lengthy discussion with the prosecutor yesterday, as well as with my client. We're not quite there yet. I'd ask court to consider a 30-day adjournment. I anticipate that in those 30 days, we will likely be prepared to proceed forward with either some kind of plea agreement or the docketing of a trial.
Okay, Ms. Cope.
Your Honor, we learned yesterday that Mr. Bremer, in violation of his bond conditions, has been making contact with the victim in this case. He's called her multiple times. The bond conditions are very specific that even if he's in custody, that bond condition applies. I did talk to the jail administrator about this yesterday. To the extent that he tries to continue this behavior or tries to do this through other parties, we'll be filing a motion on that matter. The plea will be withdrawn at the next hearing. We need to get this case either set for trial or pled out. I have spoke to Mr. Trush numerous times. I've made my plea offer. I've given him an alternative plea offer, which I think is probably worse, but fit some of his concerns. So we need to make a decision on this relatively soon. Thank you.
So I will set this for a plea hearing and status conference in about 30 days, Mr. Bremer. Between now and then, I'm sure Mr. Trush will be in touch with you. And we'll go forward at that time, either with plea or the court will set it on the trial calendar. Mr. Trush, anything else I can address for your side?
So Your Honor, a couple things in regards to the contact that I do want to address to the court. And I recognize we're not here with like a motion. And frankly, I mean, he's unable to post his bond. So I don't know how effective a motion there would be to violate his bond conditions. But I do think there are some important things for the court to recognize in regards to that. When Mr. Bremer was arraigned, he was in the hospital. He was arraigned from a hospital bed. He indicated to me that he was not able to hear a lot of the proceeding as it was going on. I don't know that he was aware of that provision until it was brought to his attention by the correction staff. When he had made those contacts, frankly, the correction staff had brought him the tablet and the phone to make them. I mean, it wasn't as if he was surreptitiously hiding what he was doing. I don't think it's indicative that he was trying to violate the bond as much as that it was never read to him or given to him in a way that he could process it. He remained at the hospital, I think, for 6 weeks to 2 months after the arraignment before he was finally brought over to the jail. It's just developed in a non-traditional way. And Your Honor, I think in the court, Ms. Bremer is here and could address her directly. I think she would indicate that she is not opposed to having contact with him at this time. But again, I would ask the court, I can't speak for her.
Well, I don't have a bond issue up in front of me today, so I'll take everything that both counsel have said here into consideration if that's an issue at some point. And I'm not going to, at this point, amend any bond conditions without a formal motion. Both sides being required. So.
Understood, and if that's appropriate, we'll file such.
Okay, all right, so we'll go forward next month. That's all for this week.
Thank you.
We did, the past one, he wasn't here.
Oh, okay. People versus Adam Fletcher, file number 265578. The record should reflect this hearing was set for 9 AM. It's now 9:42. Have you had any contact with Mr. Fletcher?
So a few things in regards to Mr. Fletcher's matter. So when I was here at 9 and saw he wasn't here, I reached out to my office to have him contact him. We did get a response back that he was on his way. Admittedly, I don't remember where he's coming from, but I want to say it's the Flint area.
We have a Frederick address.
Okay, and maybe that's correct. I'm not certain of that. Ultimately, he has reached out and said that he's on his way. I'm not sure why he wasn't here earlier. I do think the court probably can recall he was on the docket in Otsego County yesterday.
Oh, yeah. Okay.
He did appear there. I spoke to him there. I mean, so I mean, we have a plan as to what we're gonna do. I'm not sure if maybe he thought, because we had sort of, his attorney there, I and he all talked about what we were trying to accomplish. So maybe he didn't realize he had to be here today because he was there yesterday.
No,
I
was. We
I
talked
really
about
don't.
today, so he knows he's supposed to be here.
So, again, I don't have a really good answer for the court other than, we have a plan for what we're gonna do.
All right, so let's see if he appears. I mean, he was in court yesterday, so it doesn't make sense that somehow he would not come today. So I tend to think that it's something other than he's just deliberately evading court. However, again, we had a conversation about today's hearing with you in court, so there's no question in my mind that he was fully aware that he had to be here today. So I guess let's see where that goes. About Mr. Bowman.
A
Couple minutes early.
He had messaged me and indicated that he was on his way. He had indicated that it was trending that he might be a little late, a few minutes late. So I can go check the lobby and see if either.
Okay. We'll take let's take a couple minute break. Court calls People versus Scott Bowman, file number 265551.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Touche on behalf of Mr. Baumann.
This is the date and time set for a sentencing hearing in this matter. Mr. Baumann, if you had an opportunity to go through the report and talk to Mr. Truitt about that.
Yes, I have.
Mr. Truitt, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Spoke, do the people have any additions, deletions, or corrections?
No,
Challenges to the scoring?
no.
Anything on behalf of the people or allocation to
Your Honor, it looks like he is currently under sentence. This is a high severity felony. He has 3 prior felonies and 2 prior misdemeanors. It looks like he had probation for multiple different things, including assault on a DHS employee, a larceny in a building, and possession of a firearm by a felon. You know, I think that a sentence within the guidelines is appropriate. I would ask the court to sentence him to a jail sentence that the court feels is appropriate based on his history. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. This is a somewhat interesting case in terms of the recommendation and just Mr. Baumann's history. Mr. Baumann's history is not the worst out there. 3 prior felonies, 2 prior misdemeanors. Certainly the court probably today will see histories that are much worse than that. Not to say that there's not history there. But that history doesn't seem to support the idea of just a straight jail sentence with no rehabilitative goals in mind. Looking a little bit deeper beyond that, it appears that he's been placed on probation 4 times in the past, and most of those have not gone well. It looks like a couple of them, by my reading, at least 3 of them have had violations that ultimately resulted in either discharge or even at least violations. I think what I would ask the court to look at here, though, is I don't think that the record is at the level that we should be looking at abandoning rehabilitative goals at this point. I think that the court could craft a sentence that imposes some jail with an option for treatment. He reports to me that he has been in contact with an inpatient treatment facility with Bear River.
Yeah, the pier in Traverse City. I can be admitted today. Like I've talked to the intake counselor and they have a bed ready for me. I have my bag packed in case that I was able to go to treatment today. I know that I have a drug issue and I need to combat that.
So, Your Honor, I would suggest to the court, again, I probably would tend to agree with the probation department that given the history on probation may not be the best option. I do think that, again, a jail sentence with the option for treatment, something that incentivizes him to take those right steps, is a good idea. You know, certainly he has the ability to get into treatment on his own. I don't think that it is a mistake for us to make it the easy choice for him, right? The easier we make the right choice for him to make, the more likely he is to make it. And I think we all recognize the more times we engage with treatment, whether it's outpatient, whether it's inpatient, whether it's support groups, peer recovery coaches, sponsors, the more times we engage with it, the more tools we get. It's somewhat of a rarity for someone to just immediately engage with treatment and, you know, miraculously everything's fixed. I think I read the average number of times someone has to engage before it takes hold is 3 to 4 times. And certainly I've encountered people who have done it more than that. So I would suggest to the court, I think the recommendation here, given all the circumstances, isn't unreasonable, but I would ask court to consider allowing for entry into treatment in lieu of jail in order to incentivize him to take the right options to address the needs he has. Thank you.
Great, thank you. Mr. Baumann, anything you wanted to say?
On my behalf, sir, I mean, I know possessing this drug is illegal. I've struggled with addiction. I've never sought treatment. I'm 100% sure of this treatment will work for me. I take drug test today. I haven't done anything illegal since my arrest. I would like to, on my behalf, say that the charge that she read of assaulting a DHS worker, I've never been charged or arrested for that in my life. I don't know why that showed or what county that's out of, but I've never seen a courtroom for a charge like that in my life. I've never assaulted anybody.
And Your Honor,
Like I've never even heard that. I took a charge for felon in possession of a firearm on a plea agreement and a theft charge. Those are the only two felonies I've ever had in my life. And those are out of Rowan County, and I had a marijuana charge out of Manistee County. That's the only time I've ever seen a courtroom.
I don't know, which one were you?
It's on the front page of the PSI. It's listed as he's on probation out of Tennessee with a sentence date of 11/12/21. I will ask MDOC to contact, because we can't verify because it's from a different state. So we'll contact and see what's
Oh, I
happening.
see, assault and battery, DHS employee,
Yeah, it's right on the front page.
November 12, 2021.
and I mean, just looking at the criminal history section, it looks as though there was a, that appears to represent 9 of 10. And it looks
Yeah.
like the preceding entry, 8 of 10, was dismissed for a plea. But I mean, what's on there as under sentence doesn't really doesn't appear to correspond with that.
Okay, well, I mean, it may not be an assault of a DHS employee, but it does look like we're convicted of an assault out of.
No, that's what I'm saying. I've never even been arrested for an assault charge, sir. I know that when I first came to Michigan from Tennessee, the theft charge, I think, didn't exist in Michigan that I got in Tennessee. And
How about the possession of a handgun? Is that correct?
that was a plea agreement I took.
I was asking you.
Yeah, that's a plea agreement I did take. with
So that
possession
part
of
is
a handgun.
correct, but
Yep.
the assault isn't correct?
Yeah, no assault charge. I think my probation officer, because of the theft charge, he was trying to get the terms of probation when he entered in the DOC to get the timeline the same, maybe. I've never been arrested for that.
Maybe they had.
I don't judge.
Oh,
We'll update the PSI if that's wrong, though. We'll check on that.
all right.
Other than that, like, I understand what I did was wrong, and I've done everything from outpatient to get everything set up for the rehab for the last 5 months. I've done my intensive outpatient counseling through Bicycle Health with my Suboxone treatment. And they just contacted me 3 days ago about the rehab. And then she told me yesterday that my insurance approved it for me to be taking the rehab today. I have all of her contact information and everything else for the rehab, like if anybody had any questions about it. I told her I was coming to court today and that she set my intake time for 11:30 to 12 o'clock today in Traverse City. I just trying to be a better person for my kids and my fiance.
Well, Mr. Baumann, I did read through the pre-sentence report, so I'm familiar with what brings you before the court here today. I also read through your background and your history and so forth. And taking out that assault case, certainly you have a number of other charges that we dealt with over time. You were on probation for Tennessee at the time that this occurred. And so I take all of that information into account along with what the lawyers had to say, and of course, what you had to say here today. It does appear to me, based on the information in the report, that you do have a long-standing issue with substance abuse. And a lot of that, I'm sure, has contributed to your criminal history problems that we've had up till now, and including this case. I tend to agree with the probation department in terms of, I don't think probation is appropriate here. It's been tried a number of times. You were on probation when this happened, so it doesn't make sense to me to continue to put you on probation when you're not complying with it. The other problem with probation, your history while on probation is it indicates to me that even when you're ordered by the court to do certain things, you're not doing. And so I take that into consideration when I look at should treatment be an option here? And if you have not been able to comply in the past, it's hard for me to accept that somehow this is going to be the time that you're going to comply. So I find that a straight jail sentence is appropriate. I think it would be a good thing for you to pursue treatment, and I think you should do that. There's no reason why you can't do that once you're done serving your jail time. But in terms of the court giving you more opportunities to do that in lieu of jail, I'm not in a position to do that based on your past history and what happened in this case. The guidelines in this case are 0 to 17. I think a sentence in the lower third is appropriate to account for your conduct in this case and your past history. The court is going to sentence you to 6 months in the Crawford County Jail. You do have credit for 2 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350. A DNA testing fee of $60 and a $68 state cost. You do have the ability to seek an appeal of this sentence. Mr. Truitt, if you haven't already, Mr. Donovan. We're in it for the rest of the county.
Yeah, it's on there.
Okay, Mr. Thompson, were you ready on Mr. Doran's case?
Yes, thank you. Your Honor, can we address Mr. Fletcher's case?
Yes, sure. Back on the record in Eagle versus Fletcher.
Thank you, Your Honor. I've had an opportunity to get in touch with Mr. Fletcher and communicate with him directly myself as opposed to through staff. What he had indicated to me is when he woke up this morning, his car wouldn't start. He tried to dial a ride to get out there and get him, but they cannot, at least in a timely fashion, get him here. I would suggest to the court maybe doing a show cause hearing in 30 days would be appropriate. I don't think a bench warrant's appropriate, and I think the court has identified, I mean, the objective facts here don't suggest that he's trying to flee. He appeared yesterday in court, acknowledged apparently the hearing that he had here today. It would seem to me that when he's indicating he's having transportation issues, that would seem genuine. And frankly, we intended to ask for a 30-day adjournment to try to work out a global resolution of both files anyway, which I suspect the court already.
Let's go.
I mean, he was in court yesterday. I don't have any other fails to appear. It's his first appearance. So I wouldn't object to a show cause.
Okay, we'll set it for a status conference plea hearing in 30 days. Mr. Truitt, I'll just communicate to you what I did to Mr. Dick yesterday. He's representing Mr. Fletcher in Otsego County. I just don't want this to get whipsawed where one of you saying, well, we're going to take care of it next time in Crawford, and you're saying we're going to take care of it next time in Otsego. I'd like the two of you, and I told him this too, I'd like the two of you to work together so that the next hearing, whether it's Otsego or here or both, we do something.
Absolutely, and I would say it was, and probably my fault, but I really only recognized there were two cases probably about 10 days ago.
Okay. Fair enough, thank you. Mr. Thompson,
Yes.
Are you ready on Mr. Dorrance?
We are.
Mr. Dorian, come forward, please. We're on the record now, in two files, People versus Doring, file number 2352226 and 255475.
Sierra Coke on behalf of the people. I think we have a victim on Zoom, Brittany.
Is that for me?
Yep.
Yeah, Mr. Thompson here on behalf of Mr. Doring. We have to set for a sentencing, your file and then probation violation hearing on the probation file. Ma'am, if on the Zoom, if you can unmute, please. Can you tell me your name, please?
Brittany Werder.
Okay, so Ms. Werda, we're just getting started with this case, and in a few moments, if you want to make a statement, you'll have the opportunity to do that. So I'll just ask you to remain on the line for right now. Thank you.
Okay.
This is the date and time set for sentencing. Mr. Doring, you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson.
Yes, Your Honor.
Mr. Thompson, I did receive a number of letters in support of Mr. Doring. I did have a chance to review all of those letters prior to the hearing today. The only question I have, and this is unusual, but I received a letter ostensibly from the support dog. In this case, it's signed in the support dog's name. I just.
Ralphie,
Yeah.
I
just
believe
wanted to
Mr.
know
Doring authored that.
who wrote it.
I did, sir.
You did. Yes, sir. Thank you. Just want to make that clear. for the record. Okay, so Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor. I mean, I would note there's discrepancy between what Ms. Werder says and what Mr. Doring says. The court needs to take both of those into consideration.
Okay. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
And do you know if Ms. Werda wants to make a statement?
I believe she does.
Okay, Ms. Werda, did you want to make a statement to the court today?
Yes, Your Honor.
Okay, please proceed whenever you're ready.
September 6, 2025. I was not just picked up and thrown. You also threw me against the furnace, told my child to go to her room and shut the door. You grabbed me by my throat, pinned me against the bedroom wall by the light switch, and proceeded to bite my forehead, which I still have marks from on my head from your teeth. The anxiety that spikes if something similar reminds me of something from him. My child seeking counseling every month just to talk to somebody about what she's heard and seen him do. The job I had that was perfect for a school schedule for any mom, it got took from me September 6th. I didn't get a job where I moved till December 2025. Before that, I was struggling. My child is now homeschooling instead of being in the school that she started with her friends that she knew. What was being done to my daughter and myself was not okay, and I hope you never are able to do this to anybody else.
All right, thank you, Ms. Werder. Ms. Koch, is there anything that you wanted to say on behalf of the people for allocation today?
Mr. Thompson indicated, and I expect if we'd had a trial, we'd be hearing multiple different versions of the same story. But Brittany has been pretty consistent in what she indicated was a pretty bad assault on her. I have been dealing with Mr. Doring for my entire career here as a prosecutor. In some fashion, he has sort of trickled underneath the system. I think the jail recommendation is appropriate. He's tried probation. He was on probation when this happened. Nothing is really seeming to sink in that his behavior needs to be changed. He does have an alcohol issue that we've been dealing with in other cases, not this case, but I think they all sort of play into each other. So I think the recommendation is appropriate, given the circumstances and the nature of the assault. Thank you.
Thank you, Mr. Thompson. Anything on behalf of Mr. Doring?
Yes, Your Honor, and I would respectfully disagree with some of what the prosecutor would say, because Mr. Doring originally was on probation related to his alcohol difficulties. He's had alcohol difficulties. He would be the first to tell you about that and admit that led him to some drunk driving offenses. And led him to have to take stock of his life, to make some significant changes, and he has. And that is part of what we're trying to convey with the letters, especially from Ms. Robson, his counselor. He really has changed his life, his lifestyle, and I've known Mr. Doring for some time, and he really does present different now that he's not drinking, that he is sober. He is more thoughtful. He is really has turned his life around. And I would ask the court to take that into consideration. We do have a couple different versions of what happened that day. Mr. Doring, appropriately invoked his right to counsel that day. He did make a statement to speak to what happened in the pre-sentence report from his perspective. This did get physical. It was a very, very heated situation. These folks, I believe, were engaged. It was, from Mr. Doring's perspective, there was infidelity that he was concerned about, and that can obviously affect somebody's mental state. Mr. Doring is very apologetic for what happened, but he disagrees that there was any kind of strangulation here. He disagrees that the extent of this was anything as it's been described. And I know the court's familiar with, he said, she said situations and finds itself hearing that a lot. But Mr. Doring is someone who's also been consistent in all his interactions with me and telling me what happened. Again, he appropriately invoked his right to silence, but he wants to address the court today. I don't believe this is a situation where we should be looking to max out penalty. I don't think this is the worst case this court has ever seen along this misdemeanor assault charge. And I understand the recommendation for jail time. I understand, terminating probation unsuccessfully. Respectfully, I think 90-day sentence would accomplish the aims here, which are to keep Mr. Doring on his current lifestyle of sobriety and to try to protect the public. Again, this is an isolated incident, a very, very stressful situation. So I think a 90-day sentence would accomplish those things. Thank you.
Thank you, Mr. Doring. Anything you want to say today?
Yes, sir. I'm gonna reach in my pocket and grab that letter I wrote. Is that all right, sir?
Yeah.
This is the first time I've ever addressed the court of all my troubles of being in trouble with the law my entire life. I've always accepted my responsibility of what I did. I don't deserve this responsibility anymore. What was being accused of me. Lies were being said. So I just wanted to read this, please. To your honor and to whom it may concern, I address the court about my character as a person. Ms. Koch, you have known me for 14 years, correct?
Correct.
Have I ever been disrespectful to you in court or in public?
Well, I don't,
Well, no, I'm just
No.
saying as my character.
I'm
As
not here to answer your
Well,
question.
I
This is your opportunity to
Okay.
tell me what you want me to know.
Okay.
If you want to talk to Ms. Koch outside of court.
Okay.
you're free.
I apologize, sir. And it's just as my character, I've never been disrespectful to any, Mr. Thompson, Ms. Koch, my probation officers, both of them, or the people in the back when I was incarcerated. I've always been respectful. I always said yes sir, no sir. I've never been in trouble with them back there. You can talk to the guards in the back. On that day, I did grab Miss Word and I did throw her, yes. I was scared, I was fearful for my legs, I wanted to leave the house. I knew where it was gonna end that day, to a physical altercation. And that's where she wanted it to go, so I would go to jail and she could stay living in the house while I was in jail like it was previously. And that's when the adultery was happening. And I couldn't take it no more. I said, I wanted her to leave. She said she wouldn't leave, that she wanted to be my roommate. I said, you can't be my roommate, you need to leave. Things got heated, yes. Things got out of control, yes. I take responsibility for my actions, I think. I did grab her, I did throw her. Do I feel bad about that? I do. But I was scared, I couldn't get out of the house. She wouldn't let me get out the door, because she was standing in front of the door. I was just scared. And I just, me as a person, a year is a long time. I have other responsibilities, which nothing to take away from this at all. I have been sober for almost 3 years. I go to counseling on a regular basis. I go to treatment for AA. I have an app on my phone that has AA, so I can have on, if I ever want to drink, I can be in touch with somebody automatic. I take my sobriety very seriously. As my friends, I've lost friends because I wouldn't participate and I didn't want to drink. I wanted to change my lifestyle. And that's the truth. And I still want to maintain my progress to be a better person. As far as like lies of like hurting animals. You know, Miss Werder said that she was afraid of the animals. I love animals, Your Honor. You know, I actually bought the one dog that she has because I love animals. That's why I got another dog, because I love animals. And if you can just see like through the lies that aren't true as a character, as me as a person, you know, that's all I'm asking for, sir. You know, an equal trade, as I would say it, you know, just look at me who as a person, not for what you are heard from people. You know, I carry in my pocket, excuse me. This is how serious I take my sobriety, sir.
You gotta stop grabbing it.
I'm sorry, just like
that. I'm talking.
Okay, yes, sir, yes, sir. That was my sobriety coin, sir.
You take our security.
Very much so, sir.
Too.
I just wanted to show you my
Every time
sobriety.
you reach in your pocket, you make it nervous.
I apologize. I just wanted to show you my sobriety coin that I carry with me daily. That I'm proud of me being sober for almost 3 years. I take pride in that because I could never do it before. You know, has there been a lot of problems along the way? Yes, because they don't talk about depression and anxiety that follows when you become sober. You know, because I always use it as a crutch to help me to deal with my emotions. So, but that's all, Your Honor. I just want to, you know, take that in consideration of me as a person. You know, that's all I have to say, Your Honor. Thank you.
Okay, well, Mr. Doring had time to read through the pre-sentence report. I read through that very carefully, all the information, not just the kind of recitation of what the police report reflects happened in this case, this were the statements to police, their observations of her and her injuries and the hospital's observations. The information about your background and your circumstances, read all that information as well. As I said, I read the letters that were written on your behalf. I heard from Ms. Werda today and the prosecutor, your attorney, you, and I listened to all of that information. I take all of that into account in trying to decide what is an appropriate sentence. The letters certainly paint a positive picture of you and your character. And I say this all the time, that sentencing, nobody's all one thing. Correct. So I'm sure that in your interactions with those people, perhaps law enforcement, corrections staff, the lawyers, those can all be very positive, and all of those people may have positive things to say about you in your interactions with them. And that's certainly a factor that I take into account. But I also recognize that the crime of domestic violence is an interesting crime in that people do things to significant others, spouses, and they treat them in ways that they would never treat other people. Correct. That's the nature of that kind of offense. And so I think it's entirely possible that you're all of those things to all of those other people, but you also committed a fairly violent offense against Ms. Werda in the context of your domestic relationship with her, because there are things that come into play, factors in those kind of relationships that don't exist in all your other relationships, including those with animals. So I think both of those things can coexist at the same time. And you can be a perfectly good guy in 90% of your situations and a really bad guy when it comes to interactions with Ms. Werda. And I think I have no reason to doubt her version of what happened. I find it hard to believe that a man of your size and stature was somehow afraid of her, or somehow, you know, needed to be violent towards her to get himself out of the house. That doesn't make sense. And I think it's much more likely, given everything that I've read, that this assault took place much more in line with what she says as opposed to what you say. And that's just what I think based on what I read. I wasn't there, but everything points that in that direction. Including your past history, you've got 2 prior assaultive offenses. You have a prior domestic violence offense. I also understand that domestic violence is something that tends to be recurring. So all of those things taken into account, I do think that a significant penalty is appropriate for your actions towards Ms. past history of assault conduct. And the fact that this was violent, it could have resulted in much more significant injuries to Ms. Warda than did result. And so I think combining what happened in this case and your past history warrant a significant penalty. The court is going to sentence you to 1 year in the Crawford County Jail. You have credit for 5 days served. The court is going to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $50 state costs. This is a misdemeanor, so you do not receive anything in writing that explains your appellate rights to you, but you have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file that appeal within 21 days. If you have further questions about how to do that, Mr. Thompson will be able to answer those questions. Other than that, you are remanded to custody of the county at this time, although we do need to address the probation violation. First, that I don't believe there's been any plea to that or anything at this point.
Your Honor, based on the sentencing, Mr. McFaldo would like to dismiss the probation violation. It wouldn't make sense because he maxed out on this to go forward with it. So Mr. McFaldo wants to dismiss that probation violation.
Discharge without approval, Judge.
Okay, so the court will dismiss that and discharge Mr. Doring for his probation.
Thanks.
There you go.
I'm sorry.
Okay.
In my office, I do.
I'll see us here.
You have Mr. Iverson.
We do. You're all right. I'm just go. Less than a minute, maybe even just a minute. Sure. Tell the girl what we're doing.
Ms. Warda, this case is over. You're free to remain connected if you'd like, but you're free to disconnect as well.
Thank you, Your Honor.
All right, we'll go on the record in People versus Zachary Iverson. This is file number 265555. If I could just have counsel put your hands up.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Zachary Iverson.
This is set for a status conference today. Plea hearing, Mr. Thompson, I think you've indicated that you have the agreement, is that correct?
Yes, I believe it's my client's intention to plead no contest to one count of CSC first degree based on relation. And so that does not include the 25-year mandatory minimum. And then the other, the 25-year mandatory minimum and the remaining counts would be dismissed.
All right, and Ms. Koch, is that a correct statement of the plea offer?
It is, and the plea agreement, just so we're clear, is under the relationship, which the PAT code is 750.52B1B. So it's the same statute. It's a different section of the statute. It's still a life A grid. And typically, I know the court doesn't want to do no contest pleas in these type of cases, but there's an admission in the report. I think that alleviates the court's concerns that we sometimes have with no contest pleas.
All right.
It's an amendment of the CSC first. It doesn't change it. We're just going to change the section.
Yeah, so it's amended because it is a different subsection, Your Honor, which is what changed different mandatory.
All right, Mr. Iverson, have you had adequate opportunity to speak with your attorney about this agreement?
Yes, I have.
Is that how you wanted to proceed today?
Yes, sir.
Raise your right hand, please. Best you can.
Right.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God, Your Honor.
Thank you. Lower your hand. Mr. Iverson, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that the maximum possible penalty you could face by pleading no contest to this charge is up to life in prison. You understand?
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
No contest, Your Honor.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to have a trial by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
You understand that you're going to be giving up and waiving all of those rights by pleading guilty, and you won't have them anymore, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to do that by leave, and that means that you have to ask the Court of Appeals to hear your case. If they say no, then that's the end of the appeal, and you can't go any further with it. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here in the court today?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, Your Honor.
I have been given a Crawford County Sheriff's Department report. I need to take a second to look at that. But I'm gonna identify that as Sheriff's Department report number 26120000332. I'm gonna mark that as Court Exhibit 1. One second. Going, Ms. Koch, have you reviewed the contents of that report?
I have.
Would you agree the contents of that report would provide a factual basis for finding guilt as to count one?
I believe, yes, as to the count that we alleged, and for the purposes of the plea agreement, that would be included.
Mr. Thompson, have you done the same?
Yes, I would agree, either as to the amended count or as to the original.
Okay. So I agree that it provides a factual basis. After reviewing that, the court will admit court exhibit 1 to the file as the factual basis. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on record?
No.
Mr. Thompson?
No.
Ms. Koch, are the people satisfied that the court has complied with statute or rule in taking this no contest?
Yes, Your Honor.
Mr. Thompson?
Yes, Your Honor.
The court, Mr. Iverson, the court finds that your plea is knowing and voluntary. The court is satisfied that there's a factual basis to support a finding that you are guilty as alleged. Based on the information contained within court exhibit 1, the court will accept a no contest plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Someone from the probation department will meet with you to prepare a pre-sentence report. Once that's done, you'll have a chance to go through that with Mr. Thompson. Ms. Koch, anything further we need to address today?
No, thank you.
Mr. Thompson?
Nothing, thank you.
Okay, thank you. That's all for today.
Thank you, Your Honor.
Ms. Strasburg present.
She is.
Okay. People versus Strasburg. We have file 24529465566 and 5567. And this Strasburg is here for sentencing on 2 new files as well as sentencing on probation violation. And yeah, here full Strasburg, have you had an opportunity to go through those reports with Mr. Thompson?
Yes, sir.
Thompson, first as to the new felony charges, that PSI, do you have any additional solutions or corrections?
I do not, Your Honor. My client and I identified a couple typos on the appended PSI. But I don't think they're really game changers. And the mother's name is spelled wrong at one point. So I don't believe there's any problems with the current PSI.
Okay. And are there any challenges to the scoring on possession charge?
There is no challenge to the scoring, Your Honor.
And then as to the probation violation report, do you have any changes that need to be made?
No, Your Honor.
Ms. Koch, to the people, as to the new charge, do you have any additions, deletions, or corrections?
No, Your Honor.
And I'm sorry, Your Honor, as to additions, I believe my client has 3 letters on the court received those. Sure, I can, Ms. Koch, did you want to see these first? Sorry.
Mhm.
Okay.
had a chance to review those, Mr. Thompson. Did you want those attached to the PSI?
I did.
Ms. Coe, you said you don't have any additions, deletions, or corrections.
I do not.
Any challenges?
No.
Anything on behalf of people for allocation today?
I think the court is pretty familiar with Trosper, Ms. Trosper, and the struggle she has. She has 2 prior misdemeanors, no juvenile record, no felony. She's 44 years old. I hope that this is the last time we see her. She has definitely struggled with the probation and making good life choices. So I think she's probably at a crossroad here. I'd ask the court to sentence her appropriately. Thank you.
Thank you, Your Honor. I had a chance to meet with Ms. Trosper, and I wanted to explain a couple things to the court. The court might be able to tell that Ms. Trosper is very emotional. She's essentially scared to death today. She's got herself very worked up, and I think that's part of what occurred in her PSI interview. I think she, was remembering some of the defenses we might have had if we went to trial in this case. I talked to her about, the fact that this is sentencing. The court isn't here to evaluate legal defenses. It's here to assign responsibility and for her to take responsibility. And that is her intent today, Your Honor. I think it's true that she was overwhelmed and emotional when the police officers came to arrest her. I think she was concerned about the fact she had a lit cigarette in her hand. I think it's still objectively true that she didn't immediately comply with their orders. They had to do a takedown, which escalates things, which makes it physical, which raises the risk of injury for everybody. And Ms. Trosper is taking responsibility and is apologizing for that. She should have immediately complied. She understands that. So we could have had it, we could have tried a defensive trial. We're not doing that. We're taking responsibility. Same thing with the illegal substances that were in the bag that she was possessing. She gave, when she talked to police officers about it, there's a way we could have defended that at trial, but she is admitting she possessed that, and she is here to take responsibility for that. And in taking responsibility for that, and what she wants the court to understand is how terrified she is that she's not going to be able to fulfill all her obligations outside this courtroom, Your Honor. She certainly understands she has obligations to the court. She has a special needs child who's in special ed, is in line to end up in court right now. He's in regular school at 16. So he's an individual who needs a lot of help. He has an IEP coming up. He has all the needs that a 16-year-old would have, plus his own special needs. And she can arrange care for him, but nobody can care for him the way she can. So that's one of the things she's terrified about, and that why she's presenting so emotional today, Your Honor. She also has a boyfriend who is just having the worst run of health, and she is trying to care for him and his. She gave me all this health information today, and I haven't been able to quite digest all of it, but he's going to need a PICC line. He's going to need a pacemaker. He's going to need a defibrillator. And there are appointments that she's concerned about. She has an appointment on August 14th. That what DJ has, her boyfriend has an appointment on August 15th. And she regards herself, and she is his, something of a caregiver for him at this point. So she's asking the court to consider a suspended sentence, to recognize the seriousness of what she did and what she's taking responsibility for, but also to recognize, that she is someone who could do well on probation, that can form her actions in a way that'll make society safer and improve her own quality of life as well. So we're asking the court to consider a suspended sentence in this matter. The court reviewed the letter. She has support. She's a person who gives of herself and helps people. And I understand when she spoke to Mr. McFall that she was still kind of in that defensive mode that you're in when you're defending some very serious charges, but she is here to take responsibility. There you are. Thank you.
Thank you. Mr. Trosper, anything you wanted to say?
I'm having a hard time talking. So I apologize for everything. I worked really hard trying to do very good on all of this, and I apologize for my actions. I'm sorry. I just, I know I can do better. I don't want this to define me forever. And I know if I give him the chance, I know I can do a lot better. I know I can. I want to succeed in this. Really, I do.
So Ms. Strasburg, I read through all of the reports, the probation violation report, which tells me how, you did on probation. And then, of course, the new report that explains what happened in this circumstance. So I'm familiar with all of those facts. Of course, I'm familiar with you and your background already from the previous case. And so I take all of those things into consideration along with what the lawyers had to say, yourself. And, the problem I have, Ms. Strasburg, is that we've already been down this road one time. And I gave you a chance to avoid going to jail. I held that time in advance. And so that was your opportunity. And here we are again. And so, when you're asking the court to suspend the sentence or do something else, I already did that once. It didn't work, because here we're back. So now I'm on to the punishment part of it, because that's where we're at. Had a chance to avoid this, and it didn't happen. That's unfortunate, but that's the reality. So now it's time to pay the price for that. And so on the probation violation, the court held 6 months in abeyance at the time of the original sentencing. So the court is going to impose that 6 months. You have credit for 8 days served. The court is going to discharge you from probation and revoke the 7411 status on that case. And preserve any outstanding fines and costs, which I don't believe there are.
Paid for.
Yeah, okay. As to the new case, the court is going to order that you serve S2 file 5566, which is the resisting obstructing, 30 days in the Crawford County Jail. You do have credit for 3 days served. A crime victim's assessment of $130 and a $50 state cost. That's the file 5567. The court is going to place you on probation for a period of 24 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. Also 30 days with credit for 3 days served. On that file, a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and a $30 supervision fee while you're on probation. I was hesitant to order probation given the way the first term went, but I think having some supervision is appropriate, and hopefully we'll get you on the right track this time. You have the ability to appeal these sentences, and Mr. Thompson, if you could provide those appellate rights to you.
Thank you. So you're gonna, Your Honor, are all those sentences concurrent to each other?
Yes.
Thank you. You serve them all the same time. So you initial here, these are your documents. You're gonna take them with you. If you want to file an appeal, just go ahead and initial there. If you want to file an appeal. 6 months total. So
What about my kid, my son? What do I do?
take this with you if you want to file an appeal. These are the documents. Submit the file. You're gonna go see.
My medication over here.
Is there somebody with you? They can bring them
Bring-
around.
Yeah, he can
Bring
drop
them up,
those off to the
please.
jail.
Mr. Thompson, were you ready with Mr. Rickman's case?
I would like a moment. I don't know if the AG is here. But I would ask for a moment.
Yeah, I don't see the G connected yet. So let's take a short recess and we'll come back on the record.
Thank you.
So I got a Patricia, is she sending in on one of?
She is the victim on the Caswell case at 11:15.
Morning.
Okay, Ms. Hoffman, are you able to hear me okay?
I am, Your Honor. Can you hear me as well?
It's a little bit muted. You're not coming through real clear.
Okay. Maybe that will help.
That's better. Yep, thank you.
You're welcome.
We're just getting ready to get started in Mr. Rickman's case. He and his attorney should be coming into the courtroom here shortly.
Okay.
I'm sure she's probably in the midst of a phone call, but try.
Yeah.
I'm sorry, Your Honor. Can I have a few more minutes, Mr. Rickman?
Okay, what's the issue?
He didn't receive the PSI in the mail. There was some issue with his mailbox.
Okay.
So he's finishing that, and I appreciate the court's time.
Okay, Ms. Hoffman, if you can just stay on, I'm gonna take a couple other cases while we're waiting. Mr. Rickman is reviewing the PSI right now.
Thank you, Your Honor.
Mr. Elhart, who's your client?
Mr.
Colcom? Yes. Okay, Mr. Colcom, if you come up to the podium, please go on the record in versus Colcom. The record should reflect Mr. Colcom present here in the courtroom today. And if I could have counsel put your appearances on, please.
Sierra Coke on behalf of the people.
Craig Elhart on behalf of Mr. Holcomb stands to my right, Your Honor.
Okay, Mr. Elhart, can you tell me the status of this file?
Yes, Your Honor. I just substituted in less than a week ago. I received the police reports, I believe, the day before yesterday, and I haven't been able to review them completely yet. I anticipate doing that this weekend. Make a decision on which way to go. So I'm going to request a slight continuance. 2 weeks would be more than enough.
Let's go.
I wouldn't object to that. The plea offer in this case was made almost 2 years ago. So that can be the plea cutoff at the next hearing.
Okay, so we'll set this for staff conference plea hearing at the next date. And,
Thank you, Your Honor.
We'll go forward at that
Appreciate
time.
the courtesy.
Anything else we need to address?
No, Your Honor, not today.
Thank you. Mr. Holcomb, do you have any questions? Oh, thank you.
Thank you.
Mr.
Yeah, the courthouse.
Yep. Count one, dismiss everything else.
Thank you.
And tabs. 24.
Do you have his attorney with?
Yeah.
Oh,
And though you may not believe me, rest assured I didn't say that.
With much he says, so I believe you.
okay, we'll go on the record in People versus Kyle Wilson. This is file number 265547. If I could have counsel put your hands up, please.
Sierra Coke on behalf of the people.
Good morning, Honor. Jeffrey Rupp on behalf of Mr. Wilson, who is present with me.
Mr. Rupp, on behalf of defense, can you tell me where things stand in this case today?
Judge, I had a chance to speak with Mr. Wilson and with Ms. Koch. There's been a slightly amended plea offer whereby if he pleads guilty to count 1, safe breaking, and count 3, breaking and entering a building with intent, at time of sentencing, the people would dismiss counts 2, 4, 5, 6, and the habitual offender notice that was initially attached to count 1. In light of that amendment, it is my understanding that Mr. Wilson is prepared to enter a plea and avail himself of that opportunity.
Okay. First of all, Ms. Koch, is that a correct statement of the offer?
It is. It's been reduced to writing and provided defense counsel.
Mr. Wilson, have you had an adequate opportunity to speak with your attorney about this agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Mr. Wilson, are you currently on any kind of probation or parole?
Yes, sir.
Okay, which one?
He's on supervised release with the Eastern District of Michigan in the Federal Circuit.
Okay. And is this plea today going to result in a violation of that?
Almost certainly. There's actually already, my understanding is there is a bench warrant alleging violations for committing new offenses that was issued, I believe, in February 6th of this year, Your Honor.
Okay. And are you aware of whether or not this sentence would be required to be served consecutive to any penalty in that other case? Or whether that would affect jail credit?
Judge, without looking into it more deeply, I don't have a certain answer at this point. My experience is that the competition between state and federal, depending on whose custody he was in first, impacts where he gets credit. If he gets credit in one and not the other, has always been a very gray area of the law, in my experience.
All right. Well, Mr. Wilson, I just want to make sure that you understand that those penalties that you may face in that other case were violating based on these charges. And I don't have any control over that, and I can't tell you today what those penalties might be. Do you understand that? And you understand that those would likely be in addition to any penalty that you would receive in this case. So, and And then in terms of the maximum possible penalties in this case, under count one, safe breaking, that's a felony that carries with it a maximum possible penalty of life or any term of years. You understand that? So in that count three, breaking and entering a building with intent, that is a felony that carries with it a maximum penalty of up to 10 years. You understand that? So all of those penalties in mind, what is your plea to each of those charges today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during the trial and to not have that silence used against you, and the right to testify at a trial yourself if you want to. Understand all those rights. You understand that you're going to be giving up and waiving all of those rights, including the right to have a trial, and you won't have them anymore. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you have to ask the Court of Appeals to hear your case. If they said no, then that would be that appeal, and you won't be able to go any further with that. You understand that? Does anyone threaten you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in this court sheet? Is it your own free choice to enter this plea? Are you pleading guilty because you are actually guilty of each of these charges? The information I have indicates that this happened on or about December 12th, 2025. Is that the correct time frame? I believe so, sir. Okay. On that date, let's see, did you go into a building located here in Grayling, Spikes, Keg and Nails at 301 James Street? Yes, sir. Okay. Did you enter that building with the intent to steal something from that? Yes, sir. Did you have any permission or otherwise authorization to enter that building at that time or take anything out of it? No, sir. And then also, did you enter into a building at 609 Norway Street here in Grayling? Sure. And did you break into some type of safe or vault or container that had valuable items in it? Yes, sir. Did you do that with the intent to remove those items and put them to your own use? Yes, sir. Do you have any permission or authorization to do any of those things? No, sir. Ms. Coker, are the people satisfied with the factual basis?
Yes, but we will be asking for any restitution on the dismissed charges as well. I just wanted to put that on the record.
Okay. Mr. Rupp, is that something you contemplated as well?
So we have discussed it, and then I've explained to him that restitution is something that would be mandatory. We have not yet received, I don't believe I've received a figure yet. And so we would at this point reserve our right to have a hearing to contest the dollar amount requested.
Okay. Mr. Rupp, are you satisfied with the factual basis as to the charges?
I am, Your Honor.
Okay. Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute or rule when taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Wilson, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. It'll be in about 30 days. In the meantime, you'll be interviewed for a pre-sentence report. You'll have an opportunity to go through that with your attorney prior to the sentencing hearing once it's prepared. Spoke anything further on this file today?
No, thank you.
Mr. Crawford.
Just tangentially, Judge, I'm not sure what, if any, control you might have over it, but while he was been in custody, initially Mr. Wilson was receiving some medication. Then that was stopped. Staff told him they weren't giving it to him because he had indicated his desire to not have it. He's, I believe, attempted through several kites to make it clear that he does want his prescribed medication. I wrote a letter to the shift sergeant several weeks ago. I never got a response, but to the extent that you have any sway or control over him, he would certainly appreciate the court's chiming in and helping him get that medication.
I mean, I'd be happy if the sheriff reaches out and talk to me about that. I'd be happy to discuss it with them, but I don't have any authority to dictate to the jail what they do or don't allow. That's with the province. So maybe go try to contact the sheriff directly.
I will do that.
And I sent a letter to, or a quick note to Katie Tessner, who's our jail administrator, about this request.
Thank you. Thank you. With that, Judge, nothing further.
Thank you. That's all for today.
Do you need the
Is that the one for the file?
Yeah.
If you could get that to Sarah, please. Thank you. Mr. Thompson, were you ready?
Yes, thank you for the time, Your Honor.
Okay. Ms. Hoffman, are you ready?
Yes, Your Honor.
Thank you. We'll go on the record in People versus Rickman. This is file number 265539. The record should reflect Mr. Rickman's present here in the courtroom today. This is the date and time set for sentencing hearing in this matter. Mr. Rickman, have you had an adequate opportunity to go through that report with Mr. Thompson?
Yes, Your Honor. Good morning, by the way.
Good morning. Mr. Thompson, are there any additions, deletions, or corrections to that report?
Your Honor, Mr. Rickman will explain what happened with the assessment. We do have, some things to talk about what the recommendation are. Other than that, no changes or deletions, Your Honor.
Any challenges to the scoring? Let's go to the people have any additions, deletions, or, I'm sorry. Ms. Hoffman, do the people
Yes.
have any additions, deletions, or corrections?
No, Your Honor.
Do you have any challenges to the scoring of the guidelines?
No, Your Honor.
Okay, and Ms. Hoffman, we do have an individual, Ms. Robinson, did you wish to make a statement as a victim in this case?
Yes, Your Honor.
Okay, so Ms. Hoffman, we do have an individual here in the courtroom that's going to make a statement. Mr. Rickman, if you could be seated next to Mr. Thompson there.
Okay.
Thank you. And can you state your name?
Yes, Your Honor, Wendy Robinson.
Okay, thank you. What is it that you would like to say?
Thank you, Your Honor. I am a case manager with the Crawford County Friend of the Court. And that's how I came to know Mr. Rickman. I've known him for the past probably 8-9 years since I was the case manager assigned to his case. And during that time, I had numerous phone contact with him, in-person contact with him as well. And several of those contacts resulted in Mr. Rickman getting upset and yelling and swearing. And there was even some name calling, and there were some in-person contacts where we had to call law enforcement to make sure that things didn't escalate any further than what they were. I was also in court hearings and witnessed where he was very disrespectful to the referee as well. When having to deal with those phone calls where Mr. Rickman would become upset and yelling and swearing, of course, that caused me to have increased heart rate and, become anxious and that kind of thing. After the phone call, I would have to kind of take a break and regroup in that before going further with my work during the day. And I deal with lots of people throughout the day, and lots of people are not happy with things that I say, maybe how their case was ruled on, but they don't act like that. So that's Mr. Rickman's behavior is not the norm, I guess, if you will. In December of 2025, I was made aware of some Facebook posts that Mr. Rickman had put out there on the internet. And when I read those posts, I was really taken back by those and really concerned by those, my name being mentioned, and just harm that it appeared that he wanted to happen to myself and the referee and others. And that caused me great concern. And as a result of that, I of course notified my supervisor, my coworkers, law enforcement, and then notified my husband, and that upset him as well, of course. Had to notify family, and I have a second job, and I notified my coworkers at that job as well. And I was very thankful to law enforcement for acting as quickly as they did to apprehend Mr. Rickman so that something didn't happen. Who knows what could have happened if he wouldn't have gotten arrested. And so I was relieved when I learned that he was arrested and in jail. And then I learned that he bonded out, so I kind of back on alert, just being aware. And then as the weeks went by, my hope was that Mr. Rickman would come to realize that, he needed some help to carry. It just seemed like he was just carrying around a lot of anger and bitterness to act that way. And so my hope was that he would take responsibility and get some help in dealing with that, so that he wouldn't do something like this again. But I kind of lost a little hope when I was watching the July 9th hearing when Mr. Rickman was before this court for sentencing. And I was watching downstairs on the monitor, downstairs in my office, and I witnessed, I saw where Mr. Daniel Rickman where he made a statement that he had just made a mistake. But then he went on to say something about he had his evaluation, he had his mental evaluation or something to that effect. He had completed that. And that showed that there was no mental illness and that there wasn't any need for treatment, which he already knew, is what he said. And that then he went on to say that this was all just the friend of the court and the mother of his child making fake allegations to the friend of the court. And so when I heard that, I thought, it appears to me that Mr. Rickman still has not taken full responsibility for his actions, that he was still blaming others, and that he really doesn't think that he needs any help. And that just concerns me. And I think it should concern all of us. And my hope is that that someday that Mr. Rickman will take full responsibility and that he will get some help so that he doesn't do something like he did again. Thank you for allowing me to speak today, Your Honor. Thank you.
All right, Ms. Hoffman, are you aware of any other individuals that wanted to address the court today?
I am not, Your Honor.
All right, is there anything that you would like to say on behalf of the people for allocution? Mr. Thompson, if you and your client want to come back. Anything for, on behalf of the people, Ms. Hoffman, for elocution today?
Yes, Your Honor. One of the key issues in this case is the mental health treatment component for Mr. Rickman. We were told by his family members that he suffers from PTSD and that he had been increasingly angry since his departure from the military and that he had been lashing out at people. There are 4 separate victims in this case, all of whom Mr. Rickman should not have any contact with, notwithstanding that the plea agreement was only for one particular individual. We do want an order of no contact for the defendant with Teresa Hill, who is your FOC referee, Wendy Robinson, who has just spoken, Andrea Rickman, who is his sister, and Jacqueline. I just misplaced her name. I'm sorry about that. Spencer, Jacqueline Spencer, who is his former intimate partner and mother of his child.
It's my daughter's mother. Just let her speak, okay? You're gonna have a chance to talk. Okay.
Yes.
Go ahead, Ms. Hoffman.
And all of those women expressed concerns about his anger and his lashing out and fear that he may sometime cross the line into acts of physical violence. And we can't emphasize enough that while we want Mr. Rickman to be a productive member of society, and we are grateful for his service in the military, it's vitally important that he address the issues that are triggering the anger and the outbursts. And so we would ask for an update regarding the mental health treatment and protective provisions for those 4 named victims, Your Honor.
All right, thank you, Mr. Thompson.
Thank you, Your Honor. I want to address a couple of things on behalf of Mr. Rickman. First of all, I've spent a lot of time with Mr. Rickman, and this case is not the same as the other case. And it's not Your Honor's job to decide whether that case was handled perfectly or ruled perfectly. That went through its process. Mr. Rickman has to comply with those court orders, whether he agrees with them or not, whether they ultimately were the exact correct thing to do or not. Obviously, Mr. Rickman has his opinions about contact with his child, we love very much. And I would ask the court to try to consider his perspective on this whole thing, where, he wants to be a loving father. He wants to be in his child's life that was, restricted through a court case. And he's very upset about that. And I think anybody would be very upset about that. And he wants to obviously have his day in court on that and talk about whether that should have happened or whether that shouldn't have happened. And I understand that, and that makes perfect sense to me, that he wants to defend himself in that original case. He wants to talk about why he can and should be a good father. And I think that's a very legitimate, heartfelt passion of his, is to be a good father. But this is a separate case, and he understands that. So today is about whether he acted appropriately, and he did. He made reckless and concerning statements on Facebook. As I see it, it was probably a bit of a cry for help. He was someone who believed he was suffering an injustice. He wanted attention to that injustice. And I think a lot of things went into that. I think alcohol went into that. I think feeling very alone went into that. I understand why people would be concerned about what he said. Mr. Rickman wants it, and I think it's a very fair point that he hasn't hurt anyone, that he's not a violent person, that he doesn't engage in violence, even though he is passionate and upset about what happened in that case, Your Honor. So, we've had a lot of discussions about he doesn't have to agree with what the court did in that case, but he's still, he has to direct that passion into productive things, and that's what he's doing now. He's not drinking, he's working. When he was in the jail, he was a model prisoner in the jail. He was waking up early and doing extra chores and doing extra push-ups, and now that he's out, he's working very, very hard. He's trying to direct that passion towards productive things. He's still you know, if you want to talk about his custody case, you can talk about his custody case. I have explained to him this isn't the custody case. We're not going to talk about whether, you know, the right decision was made there. So I want the court to understand where Mr. Rickman is coming from. He is very sorry for what he did, what he said. He understands he shouldn't have done that. He apologizes. He won't do it again, Your Honor. And he has complied with his restrictions. He has complied with this, even though he's described to me how 3 different times working as a roofer with tree work, he believes that this ankle monitor has actually endangered him because he's slipped on it on the roof, or the cord is caught on it. And but he has complied with the court's restrictions since he's been released. He will continue to comply with the court's restrictions. So I think this is a well-tailored, appropriate recommendation for Mr. Rickman to continue to demonstrate how he can direct that righteous passion that we all have when we believe there's been an injustice. If he can direct that towards making himself better and doing better things with his life. So that we do ask that the court adopt the recommendation. Thank you.
Mr. Thompson, you speak to, I think, the question of the prosecutor in terms of Mr. Rickman's progress on obtaining mental health treatment.
My understanding is he went to the VA, Your Honor, and advised him of that requirement, but he was going to address that in the court. He is. Yeah. Sure. Okay. So, I mean, from his perspective, he went and they determined he wasn't eligible for further services at CMH, which is a pretty typical response people get when they go to CMH asking for help. They're told they're not eligible for services for a reason or another.
Okay. All right, Mr. Rickman, what is it that you would like to say?
Yes, sir. So I have no problem my whole life entirely admitting if I'm wrong and not just jumping through any hoop. That I also tear myself up when I do something wrong. That's why I don't do it again. So I really do chew myself up at night over anything wrong that I do. And I never said anything to my daughter's mother and this whole ordeal. She's just literally coattailing off of all of this. And I have no history of violence. I won't hurt anyone. I'm surprised we didn't have any character witnesses offered that I could have them or anything, but I could have brought 50 people in here from the community, including high-end builders and people that are respected by people that would tell you nothing but good things about me, that I love my child and that I reacted poorly to a injustice. And yes, I did in fact act poorly. I reacted poorly to what I believed was a bad decision, that there was no due process put behind the decision. I was fully ignored in the due process of the decision. And then when I went to the Judicial Tenure Commission, I received massive backlash the next hearing with an indifference to the stack of paper that I brought in there with me with Supreme Court codes, different cases, different instances to back my certain case, which were not even, they fell upon dead ears, which it's all videoed on Zoom, so it can be proven. But I did get frustrated and caught up in emotion. And I did say mean things on the internet for sure. Did I mean to hurt people's way of life? No. Did I intend on hurting anyone? No. And I didn't hurt anyone. And just so the court recognizes, I bonded out when I got arrested and I didn't have an ankle monitor on me or any crazy restrictions, no one watching me, and I didn't do anything wrong as the rest of my life. I'm not going to. I'm very frustrated about my child being taken away from me unjustly. That is something I'm going to have to chew on. And like an elephant, it's one bite at a time to eat that. So I have to do whatever I got to do. And I love my kid too much not to. The only thing I ask is that we look more into this no contact with my daughter's mother so that I can talk to my kid. Because that was literally a bandwagoning move. I said nothing to her. The screenshots they're invisible. They're buried us. They do not exist. They're not on the elemental chart. What is though is I am sorry for what I did. It was wrong. Regardless of being like punished or not for it, in my heart, I feel wrong for it. While I was in jail, I asked Jason if there was a way that we could arrange an apology tour, or something, that do some work for somebody for free or something to, a token of my, not just gratitude, but I am sorry. I feel bad when I hurt people, and I've went my whole life, if I mess up, I fix it. I do my best to fix it at least. And I just want you guys to, I know I'm not from here, so I don't have a history here, and I just want that to be known. I have solid intentions of continuing to be a good person and not actually doing anything wrong. I haven't been on the Facebook. And I've been working on let it go, let things go I can't control. If I can control them, find the safe means to travel. I know I didn't do that. I could have handled things a lot differently when I had the problems with the way that they did all that. The court, I could have just stuck right to the JTC. I could have maybe wrote you a letter. I could have wrote a different judge a letter and took a different avenue. And I know that too. There's a better way to try to fix a problem, and that wasn't the right way. And I know that it hurt people, even though I didn't take the post down because I thought I'd get in trouble. I took the post down because it was like, wow, man, that's just really mean. You should take that down before you hurt someone's feelings with it, And that's why I took it down. It wasn't because that's why it was down in seconds after I posted it, because I realized it's like, oh, I'm caught up in emotion. I'm frustrated about this whole deal. I feel like I'm not being listened to. I spend countless hours looking up Supreme Court quotes to write down on paper to bring in, and they don't even get it. I don't get to address them. It's just disheartening. I would say that it's disheartening, at least. And you look on Facebook and see a wonderful relationship between a child and a father for years and years and years, and then all of a sudden nothing, and this guy's at war with the front of the court. I mean, so I just, please take into consideration past of, no problems. And I do love people. I do my best to help people. If I see somebody struggling, I'm one of them first ones. And I wish that you've known me better than, you guys don't know me, but I wish you guys knew me better to know that. I'm not asking for any mercy or anything from you guys, just acknowledge that I care and I'm sorry, and there won't be further issues.
All right, so Mr. Rickman, I did read through the report. I'm familiar, based on the information in that report, with what took place through this incident. That report also contains information about you and your background and so forth.
Yes.
So I read through all of that. I take all of that information into account, along with what Ms. Robinson had to say here today, and the prosecutor, as well as yourself. And
yes, sir.
The defense attorney. I look at all of those things and try to take all of that into account in terms of what is an appropriate way to address your conduct here. I can certainly appreciate, as a judge with a family law docket, that people are passionate about their children and that they have strong feelings when it comes to any decisions that are made by someone other than themselves about
yes.
their child and what's going to happen with their child.
Thank you.
But I think Ms. Robinson hit the nail on the head. We have thousands of cases, and you're the only one that ends up here doing what you did. And here's another thing.
Sorry.
You talk about you want to be listened to. Strike me as somebody who wants to be listened to, but doesn't spend a lot of time listening to other people. Your first thought is to start talking again, and you're not really hearing what other people are saying, and you're going to do it right now. So I just want you to listen. Just
yes, sir.
Do your best to just listen to me as I'm talking to you.
Yes, sir.
And don't try to think of everything you want to say to me to argue against what I'm saying.
Yes, sir. That's what it is. I'm sorry.
Because that's kind of what you do, and I'm getting that in a short period of time.
Yes, sir.
It's ironic that you want to be listened to, but you don't want to listen to anyone else. And I think that's part of what might help you. But Ms. Robinson hit the nail on the head, which is we have many cases, and in almost every one of those cases, people, one side or the other, disagrees with the ruling that's made, but no one else does the kind of thing that you did. And so that should tell you that's a problem. That's something you've done that's out of the ordinary. That is a reaction that's extreme, and that you need help controlling. And I also think, you know, while you didn't cause any harm physically to anybody, it's clear from Ms. Robinson's statement, and I'm sure the other individuals involved, that you caused some, certainly some anxiety. And that's probably putting it lightly. When somebody's had those kind of statements made about them, they don't know what's coming around the next corner. They don't know what's waiting for them in the dark shadow, or when they come home. They don't know who's watching them, who's following them. It puts all of them in a state of high alert, and it's hard to live that way. And they don't deserve to be put through that because they're doing their job. And so that's another thing I think that you need to think about. There's one thing about to harm someone physically, it's another thing to put somebody in emotional distress where they have to be looking over their shoulder and everything that they do. And that's a very difficult way to live. And I think that's one of the consequences of your actions here.
I understand.
And so, you know, in this day and age, in our society now, people can't afford to just assume that somebody's going to say something and not follow through. We have to assume that they are going to follow through, because more and more people do follow through. And that's why everybody has to take it seriously. They have to be on high alert, because they don't know you and they don't know what you will do and what you won't do. You might know that, but they don't.
Yes, sir.
So I say all of that because I think it's important that you continue to follow through while you're on probation with any mental health treatment that's requested for you, because your reaction was so outside of the scope of what would be a normal reaction to an adverse ruling. Because the statements you made put a number of other people in a position where they were having to fear going through their everyday actions of life. And I think it's appropriate for you to continue to seek that out, and through probation to have that follow through on. I do think, all things considered, the recommendation is appropriate in terms of holding your jail time in advance at this time. And so I'm going to hold any jail time in advance. The court is going to place you on probation, though, for a period of 24 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed within the report. I am going to adopt the no contacts as asked by the prosecutor. I think that's appropriate, at least at this stage. The probation agent will always have the discretion to allow contact with any of those individuals for particular purposes. But your probation agent is going to be the person who's going to be in the best position to see how things are progressing and how you're doing on probation, and decide whether or not any contact is appropriate. So I'm ordering no contact unless otherwise approved by the agent. The court is going to impose 6 months in the Crawford County Jail with credit for 46 days served. The court is going to hold that remaining time in abeyance. It's important for you to understand, Mr. Rickman, that the court can impose that time at any point if you don't comply with your probation. So it's kind of a do not pass go, go right to jail kind of a thing.
Yes, sir.
And I hope that that's not the way it goes. I think we all want this to go well. The court is going to order a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a $68 state cost, as well as supervision fee while you're on probation, $30 per month. You have the ability to seek an appeal of the sentence, and Mr. Thompson, you provide and Mr. Rickman, these papers are going to explain to you how to request an appeal if you wanted to do that, as well as
Yes, sir. Thank you.
You know, I'm checking my file because I don't see it in front of me. I know we had earlier sentencing. Trying to see if I can. It's all going away. I understand that, but these are the papers that get it started. Your Honor, I don't see that as advice. The rights are in front of me. And again, I know we had another sentencing date.
will rerun the session.
Your Honor, for the record, the people submitted the Nale Proseque by email earlier this morning for the remaining 3 counts, counts 1, 3, and 4.
And I did see that email traffic and it did look to be appropriate, Your Honor. Okay.
Did it go to?
It went to Miss O'Rourke.
Yes.
Is there clarification on that mental health assessment? I never received anything. I'm not sure if that's been.
It was only released to Doug DeLeo and Jason.
Okay, so I guess as an addition of the probation, I don't know what you would need. You're saying you would need a release or?
As far as the probation goes, I understand, but as part of the plea agreement that he gets this assessment and he follows through. And I guess I haven't seen the assessment, so.
You get another copy of that?
I sure can.
Okay. Provide that.
I can also call and have that and unlock it to Mr. McFall if you would like.
I'll meet with you here.
Okay.
Yeah.
Thank you.
All right, and then, okay.
Your Honor,
He
may I
has
ask?
the- Yes.
I'm sorry, I didn't mean to interrupt. May I ask that if he has not completed the assessment, that I be notified? That that's something that is a key component to the plea agreement for our purposes.
Right. Yeah, I totally agree. And I think Mr. McFall, you're gonna kind of follow up on that and make that determination.
I just want to make sure the plea agreement was that he get the assessment, not that, and then follow whatever they recommend.
Right.
There's an also part of the plea agreement that talks about a 90-day review. Is that something that should be addressed now and scheduled, or?
I wasn't aware of that, but yes, if that's part of the plea agreement, then we'll set this for a review hearing in 90 days.
And then also the EMS portion of that, I believe part of the plea agreement, was there a duration on how long he has to be on that? I just want to make sure he understands that that's what's being ordered before I hook him up.
So the purpose of the review was to assess whether or not he continued to need the electronic monitoring. That was my understanding, as well as to see if he had complied with the recommendation and treatment orders.
So we'll address that at the night. It'll be for at least the next 90 days. And if everything goes well over that time, we're gonna meet again in 3 months and we'll take another look at whether we need to continue that.
All right, I'm told that
we have
the
an issue with it
battery's
right
not
now.
working on this. That it won't take a charge as of today, or as of
Nope,
yesterday.
yesterday.
Okay.
I'm gonna be
brought it
hooking
up.
on my own equipment.
Okay,
here.
perfect. I called the cops, let them know, went through all the channels last
I don't
night,
think
because
I won't.
I do the same thing every day with it, so.
It's not my equipment. It's good. It's the juvenile court.
It is.
Okay,
I mean, I could take it and give it to him, but
well, I can do that too. All right, I'll get that back to you. So you're gonna meet with Mr. McFall.
Okay.
All right. And we got the advice to rights in your.
I already gave it to him.
Yes,
Send it
Ms.
on.
Medler took care of that.
Okay, thank you. All right, then Mr. Rickman, just make sure you're touch base with Mr. McFall.
Yes, sir. Thank
So
you.
this is your
Thank you for
phone?
listening to me. And I'm
That's your
sorry for
phone?
interrupting.
Okay. This goes with.
I'll take that, because I'm accountable for it. Thank you.
Thank you.
Okay, thank you, Ms. Hoffman. You're free to disconnect at this time.
Thank you, Your Honor. Take care.
Are we ready on People versus Caswell?
Yes, Your Honor.
Is there anyone else that would be signing in?
No,
Someone has-
Just Patricia.
Just Patricia.
If she's feeling well enough, she said.
Okay, we're on the record in People versus Devin Caswell, file number 265533. If I could have both counsel put your appearances on, please.
Sierra Coke on behalf of the people.
Good morning, Your Honor. Ryan Slepp appearing on behalf of Ms. Caswell as president, standing to my right.
Thank you. This is the date and time set for a sentencing matter in this case. And the record should reflect Ms. Caswell's present here in the courtroom. Ms. Caswell, did you have an adequate opportunity to go through the pre-sentence report and speak to your?
Yes.
Mr. Slepp, are there any additions, deletions, or corrections to that report?
There are none, Your Honor.
Any challenges to the scoring guidelines?
No, Your Honor.
Ms. Coe, do the people have any additional corrections?
No,
Challenges to the score?
no, Your Honor.
And this is, ma'am, your name's Patricia Napier, is that correct?
Yes, that is correct.
Okay. Now would be your opportunity here at this sentencing hearing, if you wanted to make a statement to the court as one of the victims in this case. Did you wish to make a statement?
Yes, I do.
Okay.
Could I have my coworker read the statement that I have made up here? Because I'm not seeing really good. I've had cataract surgery and I'm dehydrated from this horrible bug. So I'm not there. It starts out, oh, I want to.
Hold on one second, okay? Does anybody
Okay.
have an objection to that?
No.
No objection.
Okay, yes, Ms. Napier, you can have somebody read that for you if you'd like.
Okay. Okay, now? Okay.
Yes, please.
Your Honor, I want to begin by saying that I am not here today out of anger or a desire for revenge. I am here because the choices that were made had real consequences, and I believe it is important for those consequences to be acknowledged. From my perspective as a business operator and someone whose elderly mother owns a company that my father built from the ground up, someone who worked hard to keep this company going, this situation has been incredibly painful. Our business was already struggling. We were doing everything we could to maintain what my father had built after his passing and preserve the livelihood of the people who depended on it. When my daughter-in-law, Devin, offered to come in and help, she presented herself as someone who wanted to be part of the solution. She said she would help without pay until the business could afford to compensate her. At the time, we believed she was an answer to a prayer during a difficult season. Because of that trust, we listened to her advice. She encouraged us to take out loans and make financial decisions that, looking back, placed an even greater burden on a company that was already vulnerable. We made those decisions because we trusted her guidance and because one of the owners is elderly and the other has ongoing health struggles, we believed she had our best interest in mind. After those loans were approved, Devin was given access to company funds because we trusted her. That trust was deeply violated. Instead of using those resources to help stabilize the business, money was taken and spent in ways that benefited her personally. There were frequent ATM withdrawals, personal expenses, meals for family members, and spending decisions made without regard of the impact on the company or the people who had worked so hard to keep it afloat. The creation of inflated or false invoices, including those involving her associate, Chris, was especially painful because it showed a level of planning and intent that went beyond a simple mistake. This was not just a financial loss, it was a betrayal of a relationship and a trust that was given freely. The damage from these actions has affected my family deeply. I have personally had to work harder and carry the burden of paying down debt created by these decisions. The stress, disappointment, and financial strain have been heavy. What hurts the most is knowing that someone we welcomed in and trusted chose to take advantage of our vulnerability. At the same time, I do not want this statement to be defined by bitterness. I truly hope Devin takes responsibility for what happened, learns from these choices, and understands the impact her actions have had on our family, our business, and the people who relied on it. I wish her the opportunity to move forward and make better choices in the future. But I also hope that moving forward includes accountability and a genuine effort to make restitution for what was taken. Paying back what is owed to our company would be an important step toward repairing some of the harm that was caused. Thank you, Your Honor, for allowing me the opportunity to share how these actions have affected us.
Thank you.
Okay, thank you. Ms. Napier, was there anything else that you wanted to say?
No, it's just been a very hard thing. I've never gone through so much emotional pain. It's been very hard. I'm having a hard time sleeping at night. It's affected us emotionally. We're getting by. We're coming together as a team and getting through this.
All right, thank you.
Thank you.
Ms. Coe, anything that you wanted to say on behalf of the people?
We tried to fashion a plea agreement. We worked with the victims that encompassed what happened, the length of time in which this embezzlement occurred, and the fact that Ms. Caswell has no juvenile record, no misdemeanors, and no felonies. The goal here was to get the restitution paid to the victims. So the plea agreement is slightly different than what we would normally do, but allows for her to withdraw her plea at the end if she is successful in paying back that restitution amount, which is $25,633. We would ask the court to follow the recommendation, and hopefully when we come back, she has done that.
So question, and Mr. Slubby might be able to answer this as well. But is that the amount that's in the PSI for the restitution? Is that the current amount owing, or is that the total amount? And do we have a different amount that's?
My understanding is the total amount is $25,633. And my client has a check with her today to pay that amount in full. And I think that was part of the offer, that she would be here and have her full restitution.
I wasn't sure if that was the condition that it be paid in full at the time of sentencing, or if there was. But if she's paying it in full.
She's paying in full anyway today, yeah.
Okay.
So, yes, and she did have a question about that, who to make it out to. And I thought I would ask you, but is it the circuit court that she makes the check out to?
Well, I talked to her yesterday, told her to make that to Crawford County.
Yeah. Usually it's payable to the county, and then the county disperses it.
Okay, and she has the check with her. She can put that on her today and turn it in.
Okay, thank you, Mr. Slepping.
Yes, Your Honor, thank you. My client is 49 years old. As the prosecutor correctly said, she has no criminal history whatsoever. This is the first time she'll have a conviction on her record. She is gainfully employed. She works at DoorDash right now and Uber Eats. She's married since 2015. I've spoken to my client about this case certainly many times. She would like me to take the time now to apologize to especially the victim, their family. It's a family business. We certainly apologize to everybody involved and to the court and the community as well. I believe she'll be a model probationer for you, Judge. I don't think she'll have any issues on probation. Again, she'll be able to pay in full today, the restitution. I don't believe you'll see her again. We've reviewed the PSI. I would ask you to also adopt all the recommendations, especially for the no upfront jail at this point. The 2 years probation with the possibility of getting off after a year. And then if she's successful in probation, certainly ordering that she can withdraw her plea to a misdemeanor. Thank you.
All right, thank you, Ms. Caswell. Was there anything you wanted to say?
Well, Your Honor, my lawyer said it.
All right, Ms. Caswell, I did have a chance to read through the report prior to the hearing today, so I'm familiar with the circumstance that brings you here before the court. There's also a lot of information in that report about your background and your circumstances. And I take all of that into consideration along with what the attorneys had to say and what Ms. Napier's had to say. And Ms. Napier, I do appreciate you being present. I know that you've got an illness, so it's by video, but nonetheless, it's important, I think, for the court and Ms. Caswell to hear how this has affected you. I understand that, number one, being victimized by a crime is something that is hard to deal with in and of itself. It makes you look at things differently, both from your own perspective, like how did I let myself become a victim of this type of crime? It makes you question your own practices and And then it makes you, I think, leery of other people that you encounter, makes it harder for you to trust employees in general. And certainly the family aspect of this makes it, I think, even more troubling. So
Yes.
I appreciate you making the statement here today, because it certainly gives me a better idea of how this has affected you. And I hope, Ms. Caswell, that you take that statement to heart, because when this type of thing occurs in the context of a large business, like Lowe's or Home Depot or some big corporation, they can absorb these kind of losses, but a small business like this, it could cause them to completely lose their business. And that would be unfortunate. It's hard enough for small business owners to make it on a day-to-day basis, make ends meet, let alone when they're losing funds, in particular, this significant of a loss. I do think that the resolution here is appropriate. I think the number one thing is to get them their money back so that they can continue running their business. I think number two, a period of probation so that you're being supervised is important. And I think it's appropriate as well to make sure that you don't have any prior records, and to make sure that you don't have any further contacts with law enforcement. And so I think overall it's an appropriate resolution. So the court is going to adopt that resolution. The court is going to place you on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed within the report. The most important of which it sounds like is going to be taken care of today, is payment of restitution in the amount of $25,000, $25,633. Again, that's payable to the Crawford County Clerk to be dispersed to Patricia Napier Kelly. The court will impose a crime victims assessment of $130, court costs of $325, a DNA testing fee of $60, a $68 state cost, and a $30 supervision fee while you're on probation. One thing that's not in the report that I am going to also impose is I'm not going to order any upfront jail time, but I am going to impose jail time and hold that in advance as an additional motivation to comply with the probation in this case. So the court is going to impose 6 months in the Crawford County Jail with credit for 1 day served. Again, that time to be held in advance to be served at the discretion of the court. So if you do comply with your probation, you would never have to serve that jail time. However, if you violate your probation in any way, the court can impose that jail time immediately. And so again, I hope that acts as to the extent you need additional motivation, that acts as an additional motivator to comply. You do have the ability to seek an appeal of this sentence, and Mr. Sutton, the appellate rate should be on the table there. You can have Ms. Caswell acknowledge receipt.
Your Honor, my client has signed the advice of the appellate review. May I approach?
Yep, if you want to hand that to Sarah right there, and then Ms. Caswell, we're going to have you meet with probation officers today. That concludes this hearing, and Ms. Napier, you're free to disconnect at this time if you'd like. But I'll